Hi, everyone. I'm Lynn St. an estate planning and elder law attorney. Thanks for joining me today for our Ask an Attorney Town Hall series. So we are live, so I can answer your questions as you present them. There is a chat box, or if you're on Facebook, just go ahead and ask your question, and I'll do my best to answer them for you today. So my goal with these series is to try to make estate planning more understandable, simpler. I want to present it in non-legalese terms. We know that right now these are really difficult times and people are very concerned about their own personal safety. There's more of a spotlight on what can you do to protect yourself, protect your family, and I want to be able to answer those questions and give you some guidance. So today we're going to be talking about basics of estate planning. We're going to talk about actually Medicaid, health issues, long-term care, all of those sorts of things. So one of the things that I wanted to say is that, what you do today makes a difference. A lot of people don't have any kind of estate planning documents at all. And you know what? That is understandable. I mean, it's human nature to not do things until you have to do things. And if you don't have an estate plan, I mean, I wouldn't feel that terrible. 50% of lawyers, I think is the statistic, don't have an estate plan. I think that's horrendous, but that's how it is. So I'm here though to encourage you to ask your questions, to get a better understanding of estate planning, steps that you can take, what can you do? Because what you do today makes a difference. Either, you give it some thought, you reach out to an attorney, you do something to protect yourself to get estate planning documents, or you don't. And if you don't do that, which often is what people do, inertia, people don't do things. If you don't do that, if something happens in your life, then there can be a lot of problems that arise from that. People often wait until it's too late. What's too late? Too late, a lot of times for people who are seniors, especially if they have a cognitive decline diagnosis, dementia, it means that the court is going to take over all of their affairs. If they don't have good, durable powers of attorney, a single person, they're going to become a ward of the state. They're going to be in a guardianship. Somebody's going to be managing everything for them. And it's maybe somebody they don't know, somebody they've never met. If you're married, you're in a situation where you think, well, if my spouse were to lose capacity, I can take care of things for them. That's not true. In that, if you don't have a durable power of attorney for your spouse, then if you had to sell your home and your spouse's name is on it, your spouse is going to be part of a guardianship because you don't have the legal authority to sell your home because your spouse's name is on the deed. And if you don't have a durable power of attorney, you have to go get court authority, and your loved one, your spouse, becomes a ward of the state. So, I mean, these are some real world consequences of people not taking action while they're alive to protect themselves. In this age that we're in now, we know that we're really concerned about people falling ill. And if that were to happen, let's say you're not married. Let's say you're not married, but you're in a committed intimate relationship, and you and your partner do not have the legal documents that are called healthcare powers of attorney, and you haven't named each other as the healthcare agent. What that means is if your loved one, your partner, goes into the hospital, you're not the one you're not going to have any right to see that person, talk to the doctor, get any information. Instead, the state has this priority for who would be the healthcare agent. And if you're not married and you don't have legal authority through a power of attorney, it's not you. And this is one of the most distressing things that I've seen people encounter is everybody recognizes, no, this is my partner. Could have been my partner for 20 years. It doesn't matter. You're not going to have the ability to help guide your loved one's care. And that's heartbreaking. So I'm here to encourage you because inertia is really not going to help you out and get a good plan in place. So when we're talking about estate planning, I want everybody to know you have an estate. No matter what the size of it is, you have an estate. If you're an adult, you have an estate. What are estate planning documents? Estate planning documents, and feel free to ask questions about these, are your will, durable powers of attorney for finances, for health, healthcare directives, trusts, revocable living trusts, special needs trusts, supplemental needs trusts. There's so many different kinds of trusts. So if anybody ever says trust, you got to dig deeper. What are you talking about? What kind of trust is that? There's community property agreements. There's, a lot of, you don't think of these as estate planning documents, but, like on your life insurance policy or your retirement account, you filled out a beneficiary designation that says where that asset goes in the event of your death. So that is something that has to be considered when you're looking at your estate plan. So those are the basics of estate planning documents, and I've talked a lot about those in the past. Happy to answer any questions that you have about them right now. I did get one question before we started about, what's the difference between a special needs trust and a supplemental needs trust? Again, when you're talking about trusts, don't get hung up on the title or the label to them. You've got to understand, well, what's the purpose of the trust? So kind of backing up a little bit, a revocable living trust is the common trust that most people have. It's the most the most common estate planning tool that you'll see people like financial planners or estate planning attorneys who aren't familiar with elder law or Medicaid benefits. They may recommend those, especially if they're out of state. Here in Washington state, revocable living trusts are far less commonly used. The reason for that is that we have a very simple probate process here. And in fact, it works far better oftentimes than having a revocable living trust. So a revocable living trust is a legal document you sign while you're alive, and you put all your assets into it. You have to retitle your house into it, your bank accounts into it. You can't put your IRAs in it. And the purpose of it is so that upon your disability, incapacity, or death, that somebody else is there to step in and become the trustee and do what you would have done with the assets. So upon your death, the assets go to whomever, and they do so without having to have the necessity of a probate. The problem oftentimes is that people don't understand trusts, and if you don't understand a trust, I get it. Trusts are, like I said, the most confusing legal term used when you're talking about estate planning documents. So a revocable living trust is supposed to be easy. It's revocable because you can revoke it at any time, but people don't understand that they have to fund the trust. And then people who are serving as the trustee or the successor trustee, the person after you, they don't understand that what are they supposed to do, and then they don't seek out legal guidance because oftentimes, and then it's understandable, people are reluctant to pay legal fees. Legal fees are not cheap. If you are paying legal fees that are cheap, I encourage you to ask the lawyer what is it they're doing and understand it. And if you get any pushback that, well, I don't have the time or I can't do that, you're with the wrong lawyer. You choose the lawyer. You choose somebody that you're very comfortable with, that you trust. And if you don't feel you're getting the answers and the lawyer is not being responsive, then I do encourage you to seek different legal counsel, because our job as estate planning lawyers is to protect you. And to protect you, you need to understand what it is, what we recommend for you, what do your documents do. And so don't feel like, you're asking a dumb question. You're not. It is our job to make sure you understand your plan. And if you don't, and the lawyer isn't providing the answer to you, oftentimes that's because they don't have time, or they paid you paid them like a $500 or $1,000 for a will, and that's what they did for you. You're out the door. They don't ever expect to help you out again. So you've got to be in charge of it. One of the things that's really important to us is that our clients understand things. So revocable living trusts and trusts, people get them because they don't want to pay. Your revocable living trust is that they want to kind of limit their interaction with the lawyer, and the lawyer doesn't encourage them to come back. That's one of the reasons revocable living trusts don't work out well oftentimes. In Washington, especially at what we do a lot of Medicaid and asset protection planning for people who may be focused or facing long-term care. We're likely going to recommend an estate plan that has a will as a basis to it, not a revocable living trust. The reason for that is that's the only way our state allows a spouse to protect money for the surviving spouse. So the revocable living trust is, it can be good, but it oftentimes is not appropriate. So the same thing applies if you live in Idaho as well, is that, it's the same concept. Probates in Washington are simple, probates in Idaho are super simple. So, I'm not saying everybody needs a will, everybody needs a probate. What I'm saying is understand your estate plan and don't just buy a revocable living trust because that was, something that somebody sold to you and you really didn't understand it. They are just not as useful for the most part. Now, what kind of a trust is useful? So that's what I want to help you understand. So let's say you have a disabled child. It could be a minor child. It could be an adult child, but you have somebody who is on government benefits. There are different kinds of trusts you can set up for your special needs child. You can set up a trust for them while you're alive and start funding that trust, and any assets in that trust will not interfere with your child's benefits that they get from the state. So those are, when we talk about a disabled person, we're really usually talking along the lines of a special needs trust, because you have a special needs child. But there's also you can set up that kind of asset protection trust for somebody who doesn't have special needs. Oftentimes in the will, we will include what we call an asset protection supplemental needs trust, and that could be for your spouse or any of your children or any of your grandchildren. And the reason that we will include that in a will is that upon your death, if your spouse needs asset protection or would like asset protection, the only way that we can do that in our state here, and it's also in Washington, is we do that through a will with a supplemental needs trust. So special needs trusts, think of them more for disabled children. You can set them up during your lifetime upon your death. Supplemental needs trusts, think about that you're setting that up usually for a family member or loved one, and usually that's set up upon your death. And they serve the same purpose in many ways, because assets that are in the special needs trust or the supplemental needs trust are not counted by the state as being owned by the person who's the beneficiary of the trust. And so what that means is, so for example, with the special needs child, if they're receiving government benefits, Section 8 housing, whatever they're receiving to make their life better, they can keep getting that. The money you put in the trust does not interfere with that. If you have a supplemental needs trust, for example, upon your death, what you own, the value of your estate goes into a trust for your surviving spouse. The surviving spouse then can't lose that money, can't redirect that money. See, the surviving spouse can't be the trustee. They cannot be in charge of the money. So that money there will be available to them for their benefit. And if in the future, maybe they remarry, well, your money is not going to go to that new family. Your money is going to stay in the trust for the surviving spouse and then go where you wanted it to go, which may be to your children, for example. One of the main reasons, though, for a supplemental needs trust you create through your will for your surviving spouse is that if they ever do need long-term care, the money in that trust is not going to count as theirs. So that means it will not interfere with their eligibility for benefits. and we are going to talk about eligibility for state paid benefits. So that is the way you can ensure that when you're gone, your surviving spouse will always have money. They could go to a long-term care facility for dementia for 10 years. All that money in the trust is not going to count against them. The state will pay for those long-term care costs, despite the fact you could have 200, 500, however many thousands of dollars in this trust. It doesn't matter. The trust is available to support your spouse when you're gone. If they don't need long-term care, fine. The money can be used for their support. If they do need long-term care, then maybe that money will pay for a 2-year private pay at a facility, and then Medicaid will pay. If your surviving spouse goes directly into skilled nursing, then there typically is not a private pay period. The state can pay right away, and the money in the trust then can be used to supplement and, for example, pay for a private room or a care manager or whatever's going to make their life better. So if anybody says it's a trust and don't think they're all the same, they are so different. And I haven't even touched upon irrevocable trusts and how they might be used, for example, for Medicaid planning or for tax planning. And so before I lose this thought, I wanted to mention, we are getting close to the end of this year. And if you need to do any tax planning, you have a few weeks to do that. So now is the time to reach out to your accountant, your financial planner, your estate planning lawyer, and just say, take a look at your situation and say, is this an appropriate time for me to do gifting for the annual exclusion gifting, or changing up, your retirement plans, converting to a Roth, doing anything like that. So it's a really good time, and there's not much time left before the end of the year. So do take action if tax planning, or if you have any questions about tax planning. So even though, I'm an estate planning and elder law attorney, do keep in mind that elder law encompasses also estate planning, encompasses tax planning as well. But I do encourage you, if you've got tax questions, reach out to whomever helps you with your tax planning. All right. So here's a question. Can I move property or money from an LLC easily without tax? Don't know, tax department, I'm not quite sure. 8 vintage aircraft, 6 hangars that can be moved to an established LLC. So that is a great question. When you are talking about assets and they may have certain values, different, they have different basis issues, this is definitely a great question for whoever set up your LLC. I would hope that it was a tax planning attorney. This is something that is part of a bigger estate plan with probably tax planning considerations. In the state of Idaho, depending on where this question came from, Idaho does not have an estate tax. So that's great. All they're focusing in on is the federal estate tax, which is just over 11 million right now. So if you have assets in the state of Idaho, that's what you're looking at, is your estate above the 11 million. Do keep in mind, though, that we're coming into a new year, a new Congress. The estate tax provisions that we have in place now are set to sunset, and we don't know what the federal estate tax level will be in the future. That's really anybody's guess. So that's a great reason to talk to your tax planning lawyer right now to say, hey, should we be moving some assets over? They're going to be looking at capital gains, basis issues, and those sorts of things, as well as the value of your estate. In the state of Washington, we do have an estate tax, and that's at just over, a little bit over 2 million. So people in Washington are much more concerned about avoiding the state of Washington imposing an estate tax on their death. So in Washington, we don't have any restrictions on gifting. You can gift up to 11 million without having any gift tax imposed, but there's going to be other tax considerations, for example, basis. So anyone who is concerned about the aircraft and the hangars, great time to go see your tax planning lawyer. All right, so I told you I was going to talk about long-term care and Medicaid and Medicare. So I'm going to launch on that subject now. We are going to be doing more of these Ask an Attorney, and we'll probably be bringing in some care managers to join with us because for most people, depending on, you know, what their situation is, the majority of people that are concerned about their financial future are concerned about long-term care costs. So who should be concerned about long-term care costs? Well, if you have experienced a long-term care event in your family, you've seen it in your grandparent or your parent or your spouse, you're probably concerned about long-term care costs. Sometimes I meet with clients and they have long-term care insurance, and that's great. I am a big proponent of getting long-term care insurance. However, a lot of people don't have it, or they feel they cannot afford it, or they've waited too long, because once you get that diagnosis, long-term care insurance isn't going to write you. You're too high of a risk. So, you know, it used to be in the past that there was lifetime long-term care insurance. I don't see that anymore. But long-term care insurance is a great idea. For example, if you can get it, if you can get like 3 years for yourself, 3 years for your spouse, one of you needs the coverage, you can use your spouses, you can combine it, great. That will help definitely defer or defray, excuse me, the long-term care expenses, and would help if we need to do Medicaid planning. It will definitely help because Medicaid has a 5-year look back period. So what that means is you can give away anything within 5 years of needing long-term care, and Medicaid doesn't care about it. But if you give away assets within 5 years, there are going to be consequences for doing that. So if you have a long-term care insurance policy that you can combine with your spouses to get you beyond the 5 years, or if your policy is 5 years, we can do really robust Medicaid planning that might involve you transferring all your assets to an irrevocable trust to protect those for your family, so that after the 5 years is done, all of your assets have been protected, but yet the state will pay for your care. So when it comes to, you know, there's a lot of confusion about Medicare and Medicaid. Think of it this way. Medicare is what, when you reach 65, you will sign up for Medicare, and there's the Medicare programs, Part A, Part B, there's supplemental, there's Part D for, you know, drug coverage. What I recommend you do is reach out to someone who is an expert on, you know, Medicare policies and Medicare supplemental. One person, I don't believe, can be an expert on everything. I know I am not. So I refer clients to someone who is a Medicare specialist. That's health insurance. That is not long-term care insurance. Long-term care insurance, what I was just talking about, is someone, you know, I would recommend that you go to a long-term care insurance expert. When it comes to Medicaid, Medicaid is what pays for long-term care. Medicare does not. Now, some people get confused because, well, maybe their loved one went into the hospital, they were there for 3 midnights, then they were discharged to a skilled nursing rehab. Well, if that's the case, then Medicare will cover first 20 days and partially up to 100 days if the person who needs the care qualifies. So that is because of the acute nature of the hospital stay and the need for rehab. For example, there's been a stroke or a hip replacement or something. Through rehab, Medicare will pay. But after 100 days, if that person cannot go home, if they can't be independent, if they need long-term care, Medicare is out. They're not helping out at all. So it's going to be a private pay or a long-term care insurance will pay or Medicaid. What most people do is they spend down their money, they spend down their money, they spend down their money until they have no money. And if you're a single person, what that means is you have to spend down to $2,000. That's it. That's all a single person can have. It is an impoverishment program for folks who are single. Yes, you can keep your house and you can keep your car, but you can only have $2,000 in the bank. Then you go on Medicaid, the state pays for your care, and when you die, the state basically ends up with any assets that you have. The state will recoup whatever paid for your benefits, and they'll do that by estate recovery on your house. As an elder law attorney, I can tell you there are many strategies we have to avoid that outcome. However, we can't always help clients. We can't help clients if they don't come see us, obviously, but it's very hard to do really good Medicaid strategies for a single person if we haven't met with them before this event happened. If they don't have in place good estate planning documents, if they don't have good durable powers of attorney that allow for this more sophisticated Medicaid planning that we can do. And of course, if there is, a dysfunction in the family, it's virtually impossible to help a single person preserve assets because the family's just going to fight over everything and nobody wants to go down that road. So Medicaid often is thought of as a program that's only for the poor. That's not true. It's just that's usually how people go on to Medicaid. But an elder law attorney can help a couple and can help a single person avoid that spend down. So how do you find a good elder law attorney? The best resource I think for that is you go to NAELA.org. That stands for the National Academy of Elder Law Attorneys. So NAELA.org. And what you do is you type in the location for the attorney that for the area. So you would look, if you are looking in Coeur d'Alene, you would type that in. Boise, you can type that in. We are licensed to practice law in Idaho as well. But I do find that, for example, if you're in Boise, you're going to be better served by, having that attorney that is local to you or to the loved one that needs the Medicaid planning. So what I want you to understand when it comes to a couple is that the resource standard for a couple is more generous than for a single person. Like I said, a single person can have $2,000. A couple can have countable resources of between $58,000 and $128,000. The state has a policy against impoverishing what they call the community spouse, the spouse who's not sick, the spouse who doesn't need care. So the state does allow couples to keep more money. So that's quite helpful. We can also avoid any estate recovery when we have a couple if we can transfer all assets to the name of the well spouse from the ill spouse. So we apply for Medicaid, ill spouse goes on Medicaid, the state pays for the care. We can put the house and all the bank accounts and all the assets that we can into the name of the well spouse. And that way, when the ill spouse passes away, the state doesn't recover anything. At least in Washington, Idaho's rules are different and not the same. So really be careful. If this, when I was saying you can avoid estate recovery, that applies for Washington state only. So let's say a couple has more assets than that. Maybe they have properties. Maybe they have a cabin. Maybe they have, 200,000 more than what they're allowed. Can we protect that? Yes, we can protect all of that. We can do that through the Medicaid strategies that are available. Now, Does everybody know that? No, only attorneys who really practice and focus and have a niche practice in Medicaid. And when you interview an attorney, you should ask them, do you have any Medicaid applications currently going on right now? And if the answer is no, or yeah, I had one last year, that's problematic. You have to keep current. You have to be continuously working in that arena of Medicaid. So we prefer to make sure that we put every tool in place to protect clients. It starts with having a robust asset protection estate plan at the start. Because if we have that in place, then that we know no matter what comes down the road for this client, be it long-term care, Medicaid planning, or if they need that, the documents we've put in place will help make that planning so much easier and give us the ability to do planning at the time of Medicaid. And if they never need Medicaid, then what we know is at the end of life, when there is a probate, because there does need to be a probate if you have a will and you want to protect assets for your spouse, the probate goes so much simpler and easier than if they hadn't done any kind of asset protection estate planning. The majority of people have no asset protection in their wills. When I'm saying asset protection, I'm not talking about big, huge estates. I'm talking about giving the couple peace of mind that they know, even if they have an estate that's, you know, a house and $200,000, they know when the first spouse dies, the survivor is going to have that money available to them for the rest of their lives, and they will never have to worry about spending down to $2,000 because it won't happen. They will have money in that asset protection trust. So when it comes to asset protection trusts, I hope I answered that question about, you know, what does that mean? You know, and I think that people sometimes think of asset protection meaning multi-million-dollar estates. That's not how we use the term. We talk about it in kind of the real person arena. Who could run out of money? You might have $1 million, you and your spouse. You might have $2 million, or you might have 100,000 or less. You know, anywhere in that ballpark, there is the possibility of running out of assets, because when you're in skilled nursing care, that can run $150,000 a year. If you have a long event, which could be 5 years, it could be 10 years, sometimes Alzheimer's is that long, you can see just doing the math that people, you know, might be concerned that they're going to become impoverished, and we want to make sure that doesn't happen. You worked too hard for what you have to have it all be spent down because you didn't do planning. So that's really my message, is I encourage people to do planning, because a lot of people don't understand that there are all these tools, all these strategies, things that you can do, but you're not going to benefit from them if you don't reach out to an experienced estate planning and elder law attorney. And if you're working with an estate planning attorney, just ask them the question, what happens if my spouse or I need long-term care in the future? If they say that I'm going to refer you over to a Medicaid planning attorney, you know what that tells you? You don't have an estate plan that's going to support Medicaid down the road. And even if you think, I'm never going to need Medicaid, believe me, nobody ever wants Medicaid. Nobody ever wants to go on it. But if your estate planning attorney says, well, I'll refer you to elder law group or to somebody who does Medicaid planning, you know, you likely don't have the right estate plan in place that I could even help you later on down the road. So being with an attorney who can take you from the place you're at all the way through end of life, no matter what happens, I think that that's really, really important. All right, so a couple of questions that I have about Medicaid that I was asked. Oh, one of the questions that people get really confused about is, everybody knows that there's a 5-year look back period, or most people do. Sometimes people think it's 3 years. And if you think it's 3 years, that came from before 2006. So you've got a good long memory. But they say, well, there's a 5-year look back. So how do I transfer assets to my spouse? It's like the 5-year look back does not apply between spouses. So, and that includes domestic partners. It does not apply. The 5-year look back only applies to third parties. So somebody that you're not married to. It applies to your kids. It applies to anybody who's not your spouse or your domestic partner. There are a lot of exceptions to giving away assets within this 5-year look back rule. For example, let's say you're a single person and you have a house, and let's say you have $100,000, and most people in that situation, and they're going into the skilled nursing, they're just going to spend down their money, and then the state's going to get the house. That's what's going to happen. Spend down their money on care. If they go to an elder law attorney, the elder law attorney is going to say, well, tell me, who in your family is deemed disabled? Oh, well, my son, my 55-year-old son, he had a back injury from his job, and so he gets SSDI payments. And, you know, this is my son, and I wanted him to get my estate anyway. Let's say we make it easy. There's just one son. We can transfer the $100,000 to the son. We can transfer the house to the son. Mom immediately will qualify for Medicaid benefits for the state to pay for that skilled nursing care. The son gets the house, the $100,000. It does not interfere with his benefits. No spend down. We protected 100% of the assets. So I want you to keep that in mind when you'll hear from people, from even attorneys or from your financial planner or for, you know, your neighbor. Oh, well, you got to spend everything down. It's like, question the source of that information. Where did that come from? Did that come from an experienced elder law attorney? And before you say, hey, there's nothing I can do seek out, you know, an elder law attorney who can help answer that question. So that's just one example of an exception to the 5-year rule that can make the difference for a family, that can preserve all of what they worked hard for. That's just one example. And there's many others that could apply, but I wanted you to be aware of that. Another question that we often get with a 5-year look back, because, you know, we talk about the wills with asset protection, that you as a couple can protect assets for the surviving spouse if you do it through the will that has this right kind of trust in it, the supplemental needs trust. They go, well, doesn't that run afoul of the 5-year look back? No, it doesn't. As I said, the 5-year look back does not apply to, you know, between spouses. If you're a single person, let's say, and you want to protect money for your child, you want to keep charge of your money during your life, but when you're gone, you want to make sure your child has it. But maybe you're concerned that your child is in a bad relationship, or maybe they have, you know, drug, alcohol, or other lifestyle issues. And, you know, it just runs the gamut of why you might want to protect money for your child. Single person, same thing. The will that they have can create a supplemental needs trust for the benefit of that child, so that all that money is protected from them and it's not subject to any creditors, claims, loss, financial exploitation, doesn't interfere with government benefits, etc. So what I want to encourage you to do is think about your situation. Everybody's situation is different. Sometimes clients come in and we do for them a pretty simple estate plan, one that avoids probate. You know, that on their death, everything automatically is going to go to whomever they want it to go. We can do that, but we still want to take the time to think through what I call the what ifs. What if this happens? What if that happens? Life is uncertain, but the job of an estate planning and elder law attorney is to take the time to talk with you about the what ifs, because most of the time people don't think through those things, and you shouldn't. You know, that's not your job. That's not your area of expertise. That's ours. So I encourage you, reach out, you know, interview whomever you are going to be working with. if you choose to try to do it on your own, you know, go online. What I will say is maybe you'll get the right form, maybe you won't, but I can guarantee you will not get the type of counseling, which is really what it comes down to, is that planning by somebody who can see things down the road that would benefit you. So thanks for listening. I really appreciate your time today. I hope everybody stays safe. Take care of yourself. Take care of your loved ones. Thanks for being with me today.